Hi everyone, I'm For McMahon, and our group's topic is the defamation of celebrities. So I will be starting us off, then I'll pass it on to Taylor Kim, and then to Faith Alabi, and then to Megan Jang. So we'll be introducing some cases mixed in with a lot of definitions such as defenses, requirements, and social media defamation as well. So on to the next slide. So we're just going to go over a couple basic definitions of what defamation is. So defamation is saying false things about others that can cause harm. It could also be stated that a false statement that could lead a reasonable person to have a lower opinion of someone. It's a type of intentional tort. It's an intentional act that results in damage, and it also isn't covered by the freedom of speech. So the idea of a reasonable person is a very tough topic to talk about because, like Robert said in, say, the harassment examples, as well as any other examples he talked about in the case, there is no black and white. There's no consensus. So usually there's a lot of arguments about that. So that's why there are 4 elements that make up defamation, and that's what Taylor will talk about briefly. Defamation doesn't always have to be against one person. It could also be against a business or a group of people as well. So on to the next slide. I'm going to be reviewing a case here involving Patrick Kane. I don't know if anyone's heard of this case or knows who Patrick Kane is, but he's an NHL star, and this happened back in 2015. So the case goes as one night, a woman and her friend went out for some drinks, and they met up with Kane, and they went back to Kane's house in Hamburg, Buffalo. It was driven by his chauffeur, who was actually an off-duty police officer, and she claims she was raped in his bed. So the following morning, she immediately went to the hospital for a rape examination kit. So on to the next slide here. After the rape kit evidence was taken into consideration and put together, it was found that the evidence actually worked against her and that there was no forensic evidence that contradicted the plaintiff or tended to contradict the plaintiff. Throughout the rest of the case, it was found that it was very rife with unreasonable doubt, which was quoted by Kane's lawyer and the plaintiff's lawyer, and a lot of her evidence didn't support her allegations. So on to the next slide here. After the fact, the victim refused to kind of work with authorities to find any evidence, as well as she signed a non-prosecution affidavit, which pretty much put the case on halt. It was said that there was a lot of stress put on her family, as many people were trying to find her identity and publicly shame her on social media. One female reporter who was talking to her about the topic was actually had to avoid her office because there was many threats of people who saying that they were trying to kill her and that they knew her daily schedule, which was a very rough situation. Even some local newspapers published photographs of her father and revealing details about her identity without directly doing so, without naming her, to avoid any lawsuits or anything like that. There was even a rape kit dropped off at her mother's house as a hoax. And that's kind of when things got really rough. Even the accuser's lawyer said he was not surprised and agreed that the case was rife with doubt. Throughout the entire case, Kane's lawyer made sure that he had made no incriminating statements. He even stated at the end that he did nothing wrong. And the case was later dropped for lack of evidence. But however, this didn't end in the courtroom, obviously, because as any of you guys who follow hockey know, throughout the next 5 years, even up to today, there's still a touchy subject about that. Anyone who doesn't like Kane or even the Blackhawks will even, chant rapist or no means no. And even if you didn't believe that he was at fault, you still in the back of your mind always have that kind of tagged yourself. And that's why it's a very hard subject, because that didn't affect him financially, as he was already in the contract, but reputation-wise, it definitely affected him because for a little while he was in a lot of hot water and there was a lot of kind of ambiguity about what was going on. And even to this day, even though it has gone down quite a bit, it is a very touchy subject. So now I'm going to pass it off to Taylor here.
Thank you, Ford. Now, for a statement to be considered defamatory, it must meet several requirements. The statement must be a publication of some sort, of a false derogatory statement that refers specifically to the plaintiff and that harms the plaintiff either reputationally or financially. It's important to note that publication occurs when a statement is communicated to a third party because what a tort is really concerned about is the protection of one's reputation. If harsh words are spoken in private between two individuals, this doesn't qualify for defamation because reputation can't be damaged without that third party being present and their views of you subject to change. Moving on to the next slide. In 2011, Katie Holmes announced she would be taking Star magazine to federal court under defamation and libel torts. Katie Holmes is a well-known actress, and at the time of the suit, she was 32 years old. Star magazine is a celebrity gossip magazine founded in 1974 and has had some other run-ins with celebrity issues in the past regarding to what they've published. For example, they've had a lawsuit when they falsely announced the drummer of the band Kiss, Peter Criss, for being a homeless alcoholic even though he was not. Even Jennifer Aniston at one point criticized the magazine for failing to verify the sources of their information and in the process unnecessarily damaging the lives of celebrities in their articles. Moving on to the next slide, let's find out more about what exactly happened with Katie Holmes and Star magazine. In January 2011, Star magazine printed an issue with the cover headline reading, "Addiction Nightmare, Katie Drug Shocker." Locked inside the magazine, you will find statements saying things along the lines of Holmes was trapped inside a drug cycle of addictive treatments. Also inside the magazine are references to practices of the Church of Scientology's treatments and the fact that Holmes and her husband at the time, Tom Cruise, was a member. A very different message to what the cover suggested. Specifically, the magazine claimed they were concerned about the church's and Holmes' use of e-meters, a device used to induce electrical currents through the body and back to the device to measure changes in the electrical resistance of the human body. The church claims that the e-meter measures someone's mental state and can uncover hidden crimes. After being aware of the article, Holmes accused the tabloid of implying that she was a drug addict and proceeded to seek more than $50 million in damages under defamation and libel torts. The damages in question came from people who saw the cover of the issue but probably never bothered to look inside and discover that the allegations were actually not about illicit drugs used by Katie, but her involvement in Scientology treatments instead. Now moving on to our next slide, I'll talk about more about what actually happened in the outcome of Katie Holmes versus Star Magazine's case. Initially, Star Magazine stood behind their statement claiming they were raising genuine concerns regarding Katie Holmes' involvement in the Church of Scientology and the Church of Scientology's overall practices and methods in their teachings. However, as Katie Holmes pursued this case further and threatened to take them to federal court, Star Magazine settled for an undisclosed amount. They also issued a public apology in their next magazine monthly issue and made a substantial donation to Holmes' charity of choice. Moving on to our next slide, we'll talk about the tort of defamation a little bit more and look at several factors that determine whether the defendant will be held liable for their actions in a court case. Justification occurs if the defendant's statement is true, meaning the statement must be true factually. It is not valid or justified if the defendant simply believed the statement to be true. Because of the idea of burden of proof, it is up to the defendant to show the judges that they are innocent. Absolute privilege provides the defendant with complete immunity from liability. This privilege is acceptable only in circumstances where the law must urge people to speak their mind without the chance of being sued. This occurs in cases during parliamentary proceedings, amongst high government officials dealing with government business, by a lawyer, judge, or other official in the context of legal matters, and between spouses. Qualified privilege applies to situations in which the defendant has legal, moral, or social obligations to make a statement, and when the statement is made to someone who had a similar duty or interest in receiving it. Matters where this privilege is in effect includes giving job references, discussions between parents and teachers, and during police investigations. However, it's very important to note that even in these contexts, the information exchanged must only be related to business proceedings and not gossip. Fair comment is valid when a statement was made without malice and regarded an issue of public interest. The purpose of this defense is to encourage conversation amongst the public on significant social issues. There are 3 requirements that need to be proven by the court in this defense. 1. Informed opinions. The statement must be of opinion yet supported by fact. 2. Public interest. The statement must be related to an issue of public importance. And 3. Honestly held, which means the statement must be able to have been believed by another individual other than the defendant. This third requirement is a somewhat new requirement and was a modification of the old one, and this makes it a little bit easier on the defendant to prove that they honestly did believe what they were saying could be a view of another. Lastly, public interest responsible journalism. This occurs when a journalist, although they may get some facts of a story wrong, is acting in accordance with the standards of responsible journalism by publishing a story the public was entitled to hear. It has a few requirements, including the importance of public discussion of the issue and urgency of the matter. In the case of Katie Holmes versus Star Magazine, this would not qualify for this defense method due to their blatant disregard for factual information and their ultimate loss of the case. Now, I'll pass it off to Faith.
Okay, so I'm gonna be talking about what is called an exceptional defense in the case of defamation, which is on slide 11. So this is when the courts impose an injunction on an individual or a business, preventing them from making a defamatory statement. This usually rarely happens just because the courts do not want to infringe on an individual's right to freedom of expression or freedom of speech. And so you really have to provide evidence and prove that the statement that is about to be made against you would actually be defamatory and will hurt you financially or reputationally. In the next slide, slide 12, I will be talking about the remedies for defamation. So the main remedy for defamation is compensation in the form of monetary damages that are awarded to whoever wins the battle in court. So as Taylor already mentioned, one of the requirements for defamation is that it has to hurt the individual or corporation financially or at least reputationally. So if you can actually prove that this defamation cost you financial losses and you can prove how much those financial losses are worth, then your damages can also be awarded to cover those financial losses. In the case where it's an individual who is filing a defamation lawsuit, they could also argue that they faced personal distress and emotional distress as a result of the defamatory statements, and so damages can also be awarded to the individual in that case. For businesses and corporations, this would not be able to apply. Lastly, we all know the concept of punitive damages. This is where the court would impose an extra amount on the company who is found guilty of defamation, just so as to deter other companies or future individuals from doing that same act. So I'm gonna talk about a popular case, actually a Canadian case, and it was a 7-year ongoing battle between Vancouver businessman Altaf Ali Nazarelli and a US CEO and millionaire called Patrick Byrne. So Patrick Byrne owns and publishes a magazine, and in that magazine he published an article about Altaf Nazarelli, claiming Altaf was an arms dealer, was a drug trafficker. He always finances the Al Qaeda group and also was a member of the Italian and Russian mafias. Altaf filed a lawsuit to the BC Supreme Court in 2011 and claimed that the statement hurt him financially and also reputationally. The BC court decided that it was actually a defamatory statement made, and this statement actually caused harm to Altaf Nazarelli, which is a Vancouver businessman. So in this case, they awarded damages to him. However, the defendants were not happy with the decision and they decided to take the case to the BC Court of Appeals. So the BC Court of Appeals actually upheld the decision of the BC Supreme Court and claimed that Patrick Byrne had actually engaged in an intentional act to damage Altaf Nazarelli's reputation. So Altaf was awarded $1.1 million, which is actually quite a lot of money. It's one of the biggest awards that have been awarded by the courts in Canada, and actually the biggest in British Columbia. And what this award shows, it shows the concepts of deep pockets. Obviously, Patrick Byrne is a US CEO and a millionaire, and so he could obviously afford the damages that were awarded to Altaf. This also shows the consequences for making false statements about other people that can actually damage their reputation or cause financial harm to themselves. And this means that corporations should be able to come up with strategies to enable them to prevent themselves from being sued, and to make sure that they're actually taking the necessary steps to make statements that are true about individuals or corporation or other corporations, and they are not making statements that cannot be backed up with evidence. Lastly, this also shows the negative role that the internet can play in terms of damaging people's reputation. We have seen a lot of cases about how, a simple statement that is made about someone on the internet can actually cause severe harm to them. So next, I'm going to be passing it on to Megan, who will talk about how the defamation law is a balancing act.
All right, so now we're going to move on to slide 15, and we're going to look at how the law continues to be a balancing act. And defamation is no exception to this. The law must balance the right to freedom of speech while also trying to protect individuals from hate speech, derogatory comments, etc. But first, it's important that we go back and look at those 4 requirements of defamation, because it must meet those 4 requirements, and a lot of this is where the balancing comes in. So first, it must be public. It must be publicized. And so any conversations that are private, unfortunately, while they could be hurtful and they could be derogatory, they do not harm you reputationally or financially. So therefore, private conversations are not considered defamation. Our second requirement here, it must be a false derogatory statement. This is the main portion where that balancing comes in, because proving a statement to be true or false is very difficult. A lot of the times it can turn into he said, she said, but in the case of defamation, as mentioned before, the burden of proof falls on the defendant, not the plaintiff. So it's very important that if you are going to make statements, you have evidence. And evidence is difficult to produce in the case of defamation. So for the law, trying to balance what could be true, what could be false, whether it seems it could go one way or the other, you have to provide evidence. Third, must refer specifically to the plaintiff. And fourth, must harm them either financially or reputationally. So yeah, like I said, sometimes things can be hurtful, but they're not considered defamation unless they harm your reputation or your finances. And this can also be hard to measure. Measuring the effects on your reputation in smaller cases can be difficult to balance. What is considered damaging? What is enough damage for a lawsuit? So freedom of speech does allow you to have opinions. You can say what you want to say, but you must state that it is not fact. It is only your opinion. So that's another good defense mechanism. But not all opinions. So the line does stop at hate speech. So this can include topics about your race or your gender, etc. And then this actually brings up another really interesting point that we talked about with social media and tweets and what you can say on there and how the law is trying to balance that. And we're going to come back to that in a moment. But yeah, the balance of probabilities is very important. And as the defendant does face the burden of proof, they have to provide evidence. And that brings me into our next case, which shows just how important evidence is. So
This case study is on Lance Armstrong versus the Sunday Times. And so in this case, in 2004, world-renowned cyclist Lance Armstrong sued the Sunday Times for defamation over an article they posted accusing Armstrong of using performance-enhancing drugs. So as Lance Armstrong is a cyclist, he's a professional athlete, and he has many titles under his belt. He's won many competitions. This allegation is very serious to athletes because the use of performance-enhancing drugs can have those titles stripped from you and can be very damaging to your reputation, of course. You might not have a future in sports if you have a past of performance-enhancing drugs scandals. So the court ruled that these allegations made Armstrong out to be a fraud, a cheat, and a liar. So those are three very strong words that not only disregarding finances right now, reputationally for an athlete, that is detrimental. So in 2006, the paper and Armstrong reached a settlement of 300,000 pounds, which is about $500,000 Canadian, to compensate for the damage that his reputation incurred. And this is a really important example of how important evidence is. When you make claims and when you make allegations, especially in the cases of industries that are in publication, that's what they do, they release information. They run the huge risk of defamation. So they have to be able to provide that evidence to say that what they're saying is true. You cannot sue me for defamation to not meet that the second requirement of it being false. So while the Sunday Times felt they received true information, the lack of evidence caused them to face a 300,000 pound settlement. And in this balancing act, they can only really judge you on the evidence you present. So whether you're correct or not, doesn't matter. You have to be able to prove it. And so moving on to the next slide, 17. I chose this case particularly because it ends up doing a full circle. So 7 years later, in 2013, it was revealed that Lance Armstrong had used performance-enhancing drugs. And this resulted in the Sunday Times, of course, suing Lance Armstrong back for their settlement, along with a hefty fee to cover costs. And they ended up settling on over 1 million pounds, this is about 1.65 million Canadian, which is a lot of money. So I think at this point, Lance Armstrong is almost more well known for his name being in lawsuits and in courts than maybe as a cyclist these days. But the Sunday Times was right in their initial posting, and their lack of evidence cost them the initial lawsuit. And unfortunately, not every case comes around in a full circle like this one did, and that just proves how important evidence really is in terms of risk management, and especially for businesses that are in news or gossip. And then moving on to slide 18, coming back to social media and how the law is evolving around social media. So here I have put up a bunch of tweets that are famous for leading to defamation claims and lawsuits. Of course, Donald Trump is there, Elon Musk, which is the one we talked about in class, and then there's a few other actors, celebrities that have made very serious allegations on Twitter. So moving on to the next slide here. Social media has raised so many issues for defamation laws, and as social media allows for such easy and broad publication at the click of a button from anyone, defamation cases are becoming a lot more common, and this is forcing the law to evolve and change. And as most individuals find themselves as what they call keyboard warriors, meaning they think that they can say whatever they want, whenever they want, because they're protected behind a screen. So not only do celebrities feel like that, regular individuals, business accounts, they feel that they can just say whatever they want, and it can happen so fast. And a lot of times with social media, you can't retract it. Once it's out there, it's out there. And so in the United States, they created a law called JDART, and this stands for joking, deleted, apologized for, or responsive tweets. So this is a huge evolution in the law, and it tries to balance the interests of social platform users and protecting victims from defamatory statements. And so while JDART definitely leans on the side of freedom of speech for social platform users, here in Canada, that is not currently the case. Canada is yet to create a law specific to social media and defamation. But as these statements are being thrown out more and more often and more carelessly, it's only really a matter of time before we're going to see the law evolve again. And I really like how it does continue to move and mold to society and continue to be that balancing act. All right, so on the next slide here, we have a Kahoot game if you would like to play it. But other than that, thank you so much for listening to our presentation on defamation.